The Uniform Healthcare Decisions Act modernizes a ULC Act approved in 1993. The Act enables the use of an advance directive, which includes a power of attorney for healthcare, in which an individual appoints an agent to make healthcare decisions for them if they can't make those decisions for themselves, and healthcare instructions to let their healthcare providers and agents know what care they want, their priorities for healthcare, or the values that they want to guide healthcare decisions made for them. For example, an individual might want to say that they want or don't want certain life-sustaining care if they're experiencing a particular type of health condition. The Act also authorizes certain people to make healthcare decisions for individuals who are unable to make decisions for themselves and who have not appointed an agent to do so. And recognizing the diversity of family relationships and support systems, it expands the list of people who providers can turn to for such decisions, thus also avoiding the need to appoint a guardian or otherwise involve a court in most such situations. The Act also sets forth the duties and powers of agents and healthcare professionals, and it provides certain protection from liability when they act reasonably or in good faith.
The Act shares the 1993 Act's major goals, but provides many important improvements, reflecting decades of experience and learning. A few improvements are particularly notable. First, the Act seeks to reduce the number of adults who lack an advance directive by reducing unnecessary barriers to executing these documents. All states have enacted statutes enabling the use of advance directives, but most adult Americans have never made one. Without an advance directive, an individual's wishes are less likely to be honored, and their healthcare professionals, family, and friends may struggle to determine how to make healthcare decisions for them and to identify what decisions to make. Second, the Act clarifies when an agent has authority to make decisions for the individual who appointed them. It also addresses an issue on which state law is typically silent. What happens if a patient objects to a surrogate making a decision for them? Third, the Act adds additional guidance for determining incapacity. This is important because an agent's or other surrogate's authority to make healthcare decisions for a patient begins when the patient lacks capacity to make decisions for themselves. The Act modernizes the definition of capacity so that it is focused on a person's functional disabilities, not merely their diagnosis, and makes it clear that an individual may lack capacity to make one decision, but still have capacity to make other decisions. Consistent with changes in medical practice, the Act also expands the list of healthcare professionals who may determine that an individual lacks capacity.
Fourth, the Act authorizes the use of advance directives exclusively for mental health care, sometimes known as a psychiatric advance directive. Among other things, these specialized advance directives enable individuals with chronic mental health challenges to provide specific instructions as to their preferences for mental health care, and can be used to allow such individuals to choose to make those instructions binding in the event of an acute mental health crisis. Fifth, as previously mentioned, the Act modernizes default surrogate provisions that allow family members and certain other people close to a patient to make decisions in the event the patient lacks capacity and has not appointed a healthcare agent. The new default surrogate provisions update the priority list in the 1993 Act to reflect a broader array of relationships and family structures. Finally, the Act substantially updates the model form included in the 1993 Act. The revised form is designed to be readily understandable and accessible to diverse populations. In addition, it creates an opportunity for individuals to share a broader range of information that can be used to guide future healthcare decisions. For example, the new form provides options for individuals to indicate their care-related goals and values, in addition to specific treatment preferences. The Act will provide states with a comprehensive and contemporary framework for individuals making healthcare decisions and creating advanced directives, especially as our society becomes increasingly mobile, with individuals regularly moving and traveling between states. It is important to have a consistent and predictable framework across the states so that individuals can successfully plan for their future health needs. For more information about the Act, visit uniformlaws.org.